Hi, everyone. Welcome to our first ever virtual 1L Moot Court finals. This is new for all of us, but we're so glad that so many of you joined us. We have so many people to thank for helping us make this competition possible, starting with OU staff and IT experts Pete Kramer and Hayden Pelly, the Board of Advocates, especially our President Aston Armstrong, incoming President Zach Neighbors, the 1L Assistant Moot Court Director Kate Ricart, Scoring Director Evan Crumpley, and Judging Director Aubrey Dwyer. And the LRW professors who've worked tirelessly to create a great problem and facilitate this process, Dean Gail Mullins, Professors Aaron DeWalt, Daniel Nicholson, and Zachary Schmoke. And of course, the captain of our ship, Professor Smotherman, who juggles all things all the time and makes everything happen. So a little bit about the facts and legal issues that you're about to see today. We have two issues before the court, a First Amendment issue about free speech and a Fourth Amendment issue about the search of a vehicle. The facts of this case are Becky Redding is an employee of the Rockland City Health Department, where she works at the front desk in a clerical role, handing out brochures and giving information. She was required by her employer to get a flu shot, to which she had a very bad reaction. So she took to her personal Facebook account to express frustrations about the process and her reaction. And then she claimed she would never get another flu shot, and neither should her Facebook friends. Her post was shared by a church group she's a part of, which then the post received over 20,000 interactions on Facebook. Her supervisor became aware of the post because of phone calls from concerned parents and an email from a concerned doctor. And when asked to take down the post, Ms. Redding refused, and shortly thereafter, she was terminated. In the process of seeking an employment lawyer for her employment issue, Ms. Redding parked her vehicle in the Rockland City Jail parking lot, and ultimately, she did not remove her vehicle until 2 days later. During this time, a Rockland City police officer placed a mark of chalk on Ms. Redding's tire to determine how long her vehicle had been there. And because it was there longer than what the Rockland City statute allows, Ms. Redding was issued a citation, and because she had multiple citations, her driver's license was suspended for some time. So the issues before the court today are: first, did the Rockland City Health Department violate the First Amendment by terminating Becky Redding's employment? And second, did the Rockland City Police Department violate the Fourth Amendment by chalking Becky Redding's tire? Representing petitioner Becky Redding are 1L's Michaela Barnes and Jessica James Curtis. And representing respondents, Rockland City and Rockland City Health Department, are Robert Rembert and Tina Cannon. So enjoy the round. I'm going to hand it over to 1L Assistant Moot Court Director Kate Ricart, who will issue the call of the court, and then we'll get started.
Oyez, oyez, oyez. The Supreme Court of the United States is now in session. The Honorable Chief Justice Keene presiding. All those having cause to be before this honorable court, draw nigh and pay heed. God save the United States, and God save this honorable court.
Welcome. We are now here and ready to hear Becky Redding petitioner versus PC Cooper, Rockland City and Rockland City Police Department, the respondents. At this time, I want counsel to introduce themselves. Counsel for petitioner, Counselor 1, please announce your appearance for the court.
Jessica James Curtis, counsel for petitioner.
Counselor for petition 2, number 2, please announce your appearance before the court.
Michaela Barnes, co-counsel for the petitioner.
Counsel for respondent, Counselor number 3, please announce your appearance before the court.
Tina Cannon, counsel for respondent.
And counsel for respondent number 4, please announce your appearance before the court.
Robert Rembert, co-counsel for the respondent.
At this time, before we begin, I would like each of the judges to announce their appearances here today. Judge Mueller.
Judge Emily Mueller. I'm a special judge in Pottawatomie and Lincoln counties.
Judge Guzman.
Kathleen Guzman, interim dean at the College of Law.
Judge Mensinghani. I said.
Mifflin Mansing Honey, Solicitor General in the Oklahoma Attorney General's Office.
Judge Hunter
Mike Hunter, Attorney General.
and Judge Patrick Wyrick.
Patrick Wyrick, District Judge here in the Western District of Oklahoma.
Thank you all. All right, at this time, counsel for petitioner number 1. Ma'am, are you ready to begin your oral argument?
Yes, Your Honor.
All right, do you need to reserve any time for rebuttal? Are we doing that, ma'am?
Yes, Your Honor. My co-counsel requests to reserve 2 minutes for rebuttal.
Thank you. All right, ma'am, whenever you're ready to proceed, you may do so.
Chief Justice, and may it please the court. My name is Jessica James Curtis. My co-counsel, Michaela Barnes, and I represent petitioner Becky Redding. We ask this court to reverse the decision of the 14th Circuit and remand to the district court for further proceedings. My co-counsel, Ms. Barnes, will show how the 14th Circuit incorrectly granted summary judgment on the issue of the marking of Ms. Redding's tire, as it was an unreasonable search under the Fourth Amendment. I will show that the 14th Circuit incorrectly determined that Ms. Redding's speech was not protected under the First Amendment, and therefore summary judgment was improperly granted for 2 reasons. First, she was speaking as a private citizen on a matter of public concern. And second, her interest in free speech and the public's interest in hearing that speech outweighs the government's interest in an efficient and effective workplace. My first point, Ms. Redding was speaking as a private citizen on a matter of public concern. The 14th Circuit did correctly find she was speaking as a private citizen. This court in Garcetti v. Sabalas determined that one is speaking as a private citizen when they are speaking outside the scope of one's duties and their speech is not furthering one's job. Ms. Redding's duties did not include informing people about the legitimacy of vaccinations, and she was not directly involved in the vaccination program. She was hired to perform initial intake forms, and as part of her duties, she gave a list to clients with children under the age of 10, and one of those, that list happened to include one item, as you can see on page 10 of the record, that dealt with vaccinations. Next, the 14th Circuit too narrowly defined a matter of public concern. In Connick v. Myers, this court found that a matter of public concern is one that relates to a political or social issue or is of concern to the public. And this is determined by examining the context, content, and form of the speech. This court has purposefully only set those guiding principles as to not allow courts to inadvertently censor speech, as stated in Snyder versus Phelps. The 14th Circuit admits that there were strong emotions surrounding the.
Can you distinguish this case from our holding in Connick v. Myers, in which an employee there sent out a memo inside the office regarding things that were occurring in the office? How is this any different than that?
Your Honor, this is different from Connick versus Myers because first, this was not done during work hours, and she did post it on Facebook in a public forum. And as for the holding in Connick versus Myers that was airing a personal grievance, they said that if that had been released, it would not have informed the public of any information about the office. Whereas in this situation, she is informing the public by sharing information of the negative effects that the flu vaccine does entail for some people, as you can see in her Facebook post on page 11 of the record. So unlike Connick versus Myers, she is sharing information with the public.
And so doesn't it matter under Connick how she's sharing that information and who she's sharing it with? And Connick, was it not a inter-office survey? And how does that affect what is done with a Facebook shareable message?
Your Honor, in Connick, that the fact that it was done internally weighed into the balancing test further that it was a disruption. It weighed during the balancing test that it was a disruption during office hours. And this was not done during office hours. So that is not at play here. And yes, the fact that it could be shared also furthered it shows that Ms. Redding context and form-wise showed an intent to enter into a public debate and to share her information with the public. Whereas Connick, when it was done during work hours, that was not at play because she was not trying to enter into public debate, since it was just distributed amongst other employees. And as for the 14th Circuit did not analyze context, content, and form within a social media guideline. And although this court has never been faced with that issue, the 4th Circuit was in Liverman versus City of Petersburg. And they stated, as for forum, similar to Pickering versus Board of Education, where a teacher shared a letter with a newspaper to share his opinion, Facebook is similar to that, as you are sharing your opinion with a large group of people. And furthermore, as to context, they stated that liking other people's posts, like Ms. Redding did with Ms. Amy Schell's post, furthermore, it shows an intent to enter into the public debate.
I apologize. Are you suggesting that anytime an opinion or a perspective is shared on social media, that by dint of that very form of expression, it becomes a matter of public concern?
No, Your Honor, I am not. The content still must be one that deals with a matter of public concern. And at this situation, it does. Vaccinations are a public concern, but I'm not suggesting that that someone can post anything and just tag it on Facebook and claim it as a public concern. The content still must be there.
So when it comes,
excuse me,
Go
what
ahead.
particular role then, Ms. Curtis, would you claim that Facebook or Instagram or other means of public expression play with regard to the of public concern question?
When examining public concern, one must weigh content, context, and forum equally. None are dispositive. So since none are dispositive, it must first be content, but posting it on Facebook just further brings it to a level of sharing it with the public forum as in reference to context and forum. And to find that Redding's speech was not a matter of public concern narrows the definition and frustrating the court's intent to not allow courts to censor speech and robbing the public of educated opinions on important topics by silencing employees of speaking out out of fear of retaliation from their employers. Which brings me to my Redding's interest in free speech did outweigh the government's interest in an efficient and effective workplace. In this balancing test, the factors considered are the speech's impact on the speaker's duties, the impact on the ability of the office to fulfill its role, and the impact on working relationships within the office. And the government bears the burden of justifying the discharge. And the more substantial the involvement of public concern in the comment, the more substantial a showing the government must make of a disruption. And as for the impact—
I stop you right there. With respect to the balancing test, it seems to me that as a health department employee, whether she had a clerical role or another role that was more senior and significant, the fact that she's representing to the public as an employee of the health department, that one of the most important missions of the health department is flawed and dangerous and not appropriately suited to the public health of citizens, how in the world can you argue that the interests of the government don't outweigh her interests to engage in private speech?
Your Honor, the government here at most proves a minor inconvenience. They claim that the vaccination program was threatened and the public trust was threatened. But in Pickering versus Board of Education, this court stated that when an employee speaks on a topic that they have no more authority on than the average citizen, and it can be easily rebutted by the government, there is little weight given to the government on this factor. And it is proved that the health department could have easily rebutted Ms. Redding's statement. When you look at page 12 of the record, once a patient sought more information from a doctor about the vaccination that worked for the health department, they did ultimately decide to receive the vaccination.
But isn't the mere fact that they received 10 phone calls about this post, that they had people complaining that they were getting mixed messages from the health department, isn't that greater disruption than in Connick v. Myers, where we held that the agency doesn't have to allow events to unfold to the extent that the disruption is massive before it takes action? So how do you distinguish that?
Your Honor, in Connick versus Myers, they were claiming that they were giving deference to an employer, correctly, but in that situation, that employer was claiming that the internal office affairs and the working relationships that the speech would disrupt is what would eventually not allow them to provide services to the public. Whereas here, this is more along the lines of Pickering versus Board of Education and Liverman versus City of Petersburg, where the speech was directly to the public. Therefore, a more substantial showing is needed than was needed in Connick. And as for the 10 phone calls in 10 days, there is no proof that none of those people received the vaccination. There's just proof that—
Counselor, isn't it important that when they made the phone call, they referenced the Facebook post in order to say that they were concerned enough to call? Isn't that considered a damage that someone would start questioning or being nervous or make those phone calls? Not the phone calls were made themselves, but that it was actually referenced.
Your Honor, again, it's the fact that it was referenced does play into it, but again, it still proves minor inconvenience at best. And going back to the fact that these people did call to receive more information, and they were calling an entity they trusted, and why proof by the doctor's email, that person did eventually follow the government's decision. And furthermore, the government could have easily rebutted this, like this court suggested in Pickering versus Board of Education, by publishing more facts about the vaccination. And they did not choose to do that. And these people were just inspired to find more information on the vaccine. There's no proof that none of them chose to receive it. And so therefore, there's no proof of a threat to the vaccination program itself.
Let me ask you about your client's side of the interest balancing, because she's not exactly a whistleblower revealing secret information about what the government is doing. Everybody knows the government has this vaccination program, right? She is a average citizen who happens to work for the health department, telling people a message that is contrary to the health department's mission. So how is our society's interest in her speaking, not as a whistleblower, but as just somebody inside the health department undermining the health department's mission, outweigh the health department's interest in this?
Her interest in speaking, Your Honor, is having people question their health. I mean, question their— excuse me, Your Honor. Her speaking out is inspiring people to seek more information on their health. At this day and age, that's very important. And also, if we did allow the government to outweigh her interest in this situation, in the future, lower level employees are going to not speak out based on this ruling out of fear of retaliation for their employer on situations like this. So even this is more of this would affect the future just as much as it would affect Ms. Redding. And furthermore, these factors and these contentions prove that there's a substantial question of fact in the situation, and that a reasonable person could find that the balancing test would be struck in Ms. Redding's favor, which therefore makes summary judgment inappropriate. And furthermore, Ms. Redding continued her duties uninterrupted until she was let go from her job, further proving that that was again less of no disruption on the government's part. And furthermore, for the last factor in working relationships, in Pickering versus Board of Education, they stated that speech that does not mention anyone by name, there's less weight given to the government on this factor. And Redding's post did not mention anyone by name, and she did not mention her supervisor. And furthermore, she did not supervise any employees. She had no working relationships to risk in this situation. So to allow the 14th Circuit ruling of the government's interest outweighing Ms. Redding's to stand would defy precedent and frustrate the purpose of the balancing test by allowing the government to prevail on proving a minor inconvenience at best against an employee speaking out on a matter of high public concern. The 14th Circuit erred in determining that Ms. Redding's speech was not a matter of public concern, and the government's interest did outweigh hers. To allow this ruling to stand would strike fear in government employees from speaking their mind on important topics out of fear of retaliation from their employers, therefore robbing the public of educated opinions in public debates. Therefore, we respectfully ask this court to reverse and remand the First Amendment issue to the district court for further proceedings, as Ms. Redding's speech was protected under the First Amendment. Thank you.
Chief Justice, you're muted.
Thank you, ma'am. I said, counsel for petitioner number 2, are you ready to proceed?
Yes, Your Honor.
All right. Thank you, ma'am. You may proceed whenever you're ready.
Chief Justice, and may it please the court. My name is Michaela Barnes, and I will be continuing arguments for the petitioner. The Fourth Amendment seeks to protect individuals' privacy and property from unreasonable and arbitrary intrusions by the government. Its underlying principles recognize that to allow the government to arbitrarily intrude upon the rights of the individual puts at risk the rights of all. Today, the petitioner asks this court to uphold the principles upon which the Fourth Amendment was founded by reversing and remanding the 14th Circuit decision. I will show that the 14th Circuit incorrectly upheld a grant of summary judgment against Ms. Redding's claims for 2 reasons. First, when respondents chalked Ms. Redding's tire, they conducted a search under the Jones trespass test. And second, this search was unreasonable because respondents lacked a search warrant and the community caretaking exception cannot apply in this case. To begin, when respondents chalked Ms. Redding's tire, they conducted a search. This court uses 2 tests to define a search under the Fourth Amendment: the Jones trespass test and the Katz reasonable expectation of privacy test. However, in 2012, in United States versus Jones, this court clarified that neither test is exclusive.
How can you say that this was in any way an invasion? They put a chalk mark on her tire. I don't see how that is similar to attaching a GPS to a vehicle. Those seem like 2 very different things.
Your Honor, this court's precedent as to what constitutes a physical intrusion is unclear. However, this court has previously analogized to the common law tort of trespass. If we look at the tort of trespass, it is a strict liability tort based on entrance. Whether an individual simply touches the private property of another and turns around and goes back, or continues walking and causes harm, that is an actionable tort under the law. The Jones trespass test requires that the government physically intrude upon a constitutionally protected area in order to obtain information.
So, Counselor,
The Fourth Amendment,
would your position be different if the police had merely taken a picture of the automobile?
yes, Your Honor, it would, because there would be no trespass in that case. And even if this court decided to adopt the Katz reasonable expectation of privacy test, this court's precedent recognizes that there is no expectation of privacy to mere visual inspections.
So the mere fact that they took the tire as opposed to taking a picture is sufficient to constitute an unconstitutional search?
Yes, Your Honor, it is, because there is a physical intrusion onto a constitutionally protected area. This court has extended vehicles' constitutional protection as an effect in United States versus Jones, and there was an attempt to obtain information here. The respondent specifically chalked Ms. Redding's tire.
Excuse me, what
I'm
if
sorry, Your Honor?
there were sensors underneath the parking space, and somehow, those sensors made it possible to determine when the weight of the car was atop those sensors and when that car moved? Would that change your analysis?
Your Honor, in that case, we would have to determine whether that constitutes a physical intrusion. And then we would have to look at if this court does find that it's a search, if that search was reasonable. The Fourth Amendment does not protect against all searches, purely unreasonable searches. So in this case, we need to look. This court's precedent recognizes that the specific attachment of a device to the exterior of a vehicle is in fact a search. And it was under this court's precedent in United States versus Jones that the Sixth Circuit.
Counselor, assume for a minute that I'm with you that Jones is the appropriate test. It still seems to me that there has to be some level of line drawing, that we can't actually apply that common law of strict liability. A mere touching is enough. I mean, it can't be right that if the traffic enforcement officer literally touches the car, they've searched the car, right? There has to be line drawing somewhere where the physical intrusion crosses the line from mere physical intrusion into search. And I want you to help me define that line and tell me where you draw the line between when a touching becomes a search.
Yes, Your Honor. In that case, it's the physical intrusion alone is not enough under the Jones test. There must be an attempt to obtain information. In Miss Redding's case, there was an attempt to obtain information. They specifically chalked her tire in order to assess her movement or lack of movement and identify her vehicle for the purpose of issuing a citation. They used the information they gathered from this search to issue citations. And the Sixth Circuit unanimously held in Taylor versus City of Saginaw that that is in fact a search under the Jones trespass test. Therefore, because the requirements of a search are met under Jones, this court need not inquire into whether a search occurred under the CAP's reasonable expectation of privacy test. This brings me to my second point. This was an unreasonable search because respondents lacked a search warrant, and the community caretaking exception cannot apply in this case. Warrantless searches are considered de facto unreasonable unless an exception applies. Respondents concede in the record on page 8 that at the time they searched Miss Redding's vehicle, they did not have a search warrant. Additionally, they have chosen to waive all warrant requirement exceptions besides the community caretaking exception, which is inapplicable in this case. The community caretaking exception seeks to allow officers a way to search vehicles when totally divorced from their investigative functions related to criminal statutes. It recognizes in the—
How does this differ from the Sixth Circuit's holding in United States v. Roehrig, in which they went to the defendant's home because of loud music and saw marijuana, and they were justified then in proceeding with the search? How is this any different than that?
Your Honor, in United States versus Roehrig, the government in that case had exigent circumstances that gave them probable cause to search the area. In this case, there is no probable cause. If you look at the record on page 5, there is no evidence that the officer in this case had reasonable suspicion or probable cause to believe that Miss Redding was illegally parked at that point in time. And what's important to keep in mind is that we know as a matter of fact that at the time this chalk was applied to Miss Redding's tire, she was in fact legally parked in that parking lot. This court's precedent recognizes that officers who come upon—
Excuse me. Finish your sentence.
This court's precedent recognizes that officers who come across vehicles that are damaged, disabled, abandoned, or otherwise pose significant safety risk to the public may reasonably seize those vehicles, and then once in custody, searches may be reasonable if performed in the everyday practice of securing that vehicle's contents. This would be searches such as inventory searches. However, the government's conduct does not satisfy this element. They specifically chalked Miss Redding's tire in order to assess her liability and find out if she was illegally parked. Therefore, not only did they not seize it, as this court's precedent recognizes as reasonable, but their actions were not totally divorced from investigative functions. They chalked this car specifically to investigate whether she was civilly liable or even criminally liable in this case.
So, counsel, how are police to discharge their community custodian responsibilities when a car is illegally parked? I mean, you would concede that your client was parked illegally. She was parked for 48 hours. So how are they to discharge their responsibility to manage illegal parking when there's a finite number of spaces, and particularly when it's near the police department where access is pretty important?
Your Honor, my client was parked illegally after this search occurred. However, the government does have legitimate interest in this case, ensuring efficient traffic flow and protecting and promoting the general welfare. However, they have to do so in a way that does not violate individuals' Fourth Amendment rights. As we've already discussed, they could have used regular visual surveillance to do this. They could have used parking meters. They could have used parking gates. In fact, after the decision, the Sixth Circuit decision in Taylor versus City of Saginaw, multiple jurisdictions and municipalities within the Sixth Circuit have stopped chalking tires and implemented these alternative means to cite vehicles without incident.
Counselor, can you explain if there's a difference between, you said in violation of what, a city ordinance or a criminal misdemeanor, and is there a difference here?
Your Honor, the Rockland City Municipal Code does not directly distinguish whether it is a civil or criminal statute. However, this court has applied the community caretaking exception in instances of civil liability. In South Dakota versus Opperman, this court found that a reasonable seizure occurred under the community caretaking exception when a vehicle was towed from being illegally parked in a no parking zone. The individual in that case was only facing civil liability at that point in time when the seizure occurred. Therefore, the community caretaking exception should be applied in civil cases, and therefore it is potentially applicable here. But respondent's conduct still does nothing to further a community caretaking function. The community caretaking function is supposed to be in response. The government is supposed to have probable cause, reasonable expectations that the individual is in fact in violation, or at least know as a matter of fact, like they did in South Dakota versus Opperman, that there is a danger to public safety or an impediment of traffic. None of those circumstances are present in this case. Miss Redding was legally parked at the time that they applied this chalk to her tire. Therefore, she in no way impeded traffic at that point in time, and she posed no significant safety risk to the general
let me
public.
ask you a hypothetical. If they had if the parking enforcement officer had circled back the next day and said, I recognize that car. I think that car was parked here yesterday and has now been there more than 24 hours, and chalked the tire at that point in time, would there be a Fourth Amendment violation?
Your Honor, we would have to determine whether that was reasonable. In that case, I would say that they may, in fact, have probable cause to believe that they are impeding traffic or posing a significant safety risk, either to the own vehicle or to the general public at that point in time. Furthermore, although Rockland City has been subject to a recent string and increased criminality, that does nothing to play into whether the community caretaking exception may apply in this case, because respondents' conduct does nothing to prevent against instances of theft or vandalism. If that was the government's goal in this case, they should have towed her vehicle, because it is a reasonable community caretaking function as recognized in Katie versus Dombrowski and South Dakota versus Opperman to tow vehicles in order to protect them from instances such as theft and criminality. Because the respondent chalked Miss Redding's vehicle while it was legally parked, this was a search that does not fall under the community caretaking exception. It was in no way respondent to a threat to the general public. She did not impede traffic flow at that point in time, and she did not in any way pose a safety risk. The government's goals.
The touchstone of the Fourth Amendment is reasonableness, right? We have to weigh the burdens of a search with the benefits to law enforcement. And it seems to me the burden here is very, very minimal, right? And in other contexts, like with Terry stops, we allow minor searches on low grounds of reasonable suspicion. So shouldn't there be some sort of sliding scale where we recognize that the sort of tiny dust particles of chalk is such a minimal intrusion search that it is not outweighed by the government's interest in ensuring a small but important interest in parking enforcement?
Your Honor, we must keep in mind that we are not saying that chalking tires is always unreasonable. We are saying it is unreasonable as applied within the context of this case, because respondents chose to waive all warrant requirements except for the community caretaking exception. That's what's important here. There is a sliding scale in reasonability. There's dozens of warrant requirement exceptions and multiples of those apply to vehicles. We must keep in mind that this is an as applied case. Because respondents searched Miss Redding's vehicle without a warrant and the community caretaking exception cannot apply in this case, we ask this court to reverse and remand the 14th Circuit decision. Thank you.
Thank you, counsel. Is counsel for respondent number 3 ready to proceed?
Yes, Your Honor.
All right, ma'am, whenever you're ready, you may begin.
Ms. Chief Justice, and may it please the court, good afternoon. My name is Tina Cannon, and together with my co-counsel, Robert Rimbert, we represent the respondent. I will present the First Amendment issue. Mr. Rimbert will present the Fourth. This court should affirm the 14th Circuit's decision for the following 2 reasons. First, petitioner's posts were not a matter of public concern. And second, even if her posts were a matter of public concern, the health department's interest in maintaining a disruption-free workplace outweighs petitioner's speech in this case. Respondent concedes, according to this court's holding in Garcetti v. Ceballos, that petitioner was a private citizen acting outside the scope of her employment. But respondent also recognizes that, as this court also held in Garcetti v. Ceballos, a public employee, quote, by necessity must accept certain limitations on his or her freedom. And your honors, in this case, petitioner's posts are not a matter of public concern, but they are
Excuse me,
instead.
counsel. I apologize. Ms. Cannon, I feel it would be hard pressed to think of an issue that would be of less public concern right now, particularly than vaccinations and these sorts of health and public policy issues.
Yes, Your Honor, we agree. Vaccinations are a matter of public concerns, but her comments are not. Her comments are instead a personal grievance. This court
But
has.
if we accept the proposition that, you know, so often the personal is the political, then why or how are you differentiating between someone tying this kind of concern to that person's individual circumstance?
Well, Your Honor, this court made that determination in Connick versus Myers using the content, context, and form speech. This would be similar to perhaps someone at the janitorial role in the IRS posting, "I don't like paying taxes." That is taxes are a public concern. The 16th Amendment is absolutely a valid and important public concern, but that is not contributing to that debate. In Pickering versus Board and in San Diego versus Roe.
I'm going to interrupt, counsel, because I'm actually a little surprised you take that position, because I would have thought that if an employee of the IRS posted on Facebook, "Don't pay your taxes," the IRS would be perfectly justified in firing the employee, given that that is the central and core mission of the IRS. So you seem to be saying, no, not necessarily because of their position in the organization. But to me, it seems that the important factor is, well, how important is that issue to the governmental agency that they're commenting on? Not necessarily the employee's particular importance in the organization, but if it's a core mission of the governmental agency and one of their employees is commenting on it, there's tension in the governmental agency saying it's really not a matter of public importance.
Your Honor, absolutely. That's exactly our point. Forgive me if I misspoke and was misunderstood. That speech, we would argue, would also not be protected when put under this test under Connick v. Myers. Your Honors, we are not asking the court to issue a blanket restriction on government employee speech. We are, after all, discussing the First Amendment. We are asking this court to follow its precedent in Connick and use that test, and as this court held in Waters v. Churchill, use it on a case-by-case basis. So when we apply that test in this case and we look at the content of her speech, her Facebook post is 87 words long. 4 of those 87 words.
I'm going to go back to your example regarding the janitor at the IRS. I mean, you're talking about an individual whose post was then sort of reposted to a public group that she then liked, and it's been shared over 20,000 times. That's different than one person who's a janitor having to say, "I don't like paying my taxes," versus an individual who has now had this posted out to at least 20,000 people, and that actually got back to her work and was specifically cited as a reason for not wanting a vaccine. This seems very different than the example you gave, and would actually be barred, or would be her speech would be fall under the First Amendment.
So, Your Honor, this court held in Pickering versus Connick and in San Diego that it required an informed consent. This court held in San Diego versus Roe that the dismissed employees' activities, in this case posting on Facebook, did nothing to inform the public about any aspect of the agency's functioning are operating. And we find that parallel here as well. Her post, the majority of her post The 5 out of 6 sentences, the 83 out of 87 words are all about how she feels. Her personal grievances about receiving this flu
Well,
vaccine.
hold on a second, because it seems to me you're trying to have it both ways. You're saying we let her go because this is interrupting the agency's important public mission, but also it's not a matter of public concern. Shouldn't you choose one or the other? I mean, here she's saying the flu shot just gets you sick. Now it's proof that I'm right, and I'll never get another flu shot, and you shouldn't either. It seems to be a matter of public concern if you're going to argue you legitimately let her go because it was interfering with your public mission.
Well, Your Honor, even if it is a public concern, as you brought up, it would then be subjected to the Pickering-Connick balancing test. And in this balancing test, the petitioner's post caused an actual workplace disruption. The potential for further disruption, it threatened her supervisor's authority, and it caused
Counsel,
interpersonal
I'm going to interrupt because I want to circle back because Judge Mancingani hit on the tension that I identified. And I want to make sure I understand your argument. Going back to the hypothetical you offered about the IRS janitor, I understood you to be saying that that janitor wouldn't be speaking on a matter of public concern, that we were talking about public concern. Is that your argument, or is your argument that the IRS could fire that janitor? I think you're now saying that they could fire the janitor, but fire them because they went on balancing. Is it because the janitor wouldn't be speaking on a matter of public concern, or because the IRS would be able to win at the balancing stage?
The IRS would win at both. That would be a personal grievance. And then
that's the tension we're talking about. If you simultaneously say it's not a matter of public importance, but then at the balancing stage, the governmental agency's interest in this message is so important as to outweigh their concern, it seems, as Judge Mancingani just pointed out, that you're conceding that this is a matter of public concern. That's the only way you win at balancing. So how do you reconcile that?
Well, Your Honor, even if this is a matter of public concern, for example, when we saw the court's holding in Connick v. Myers, in the 13-point questionnaire, the court found that one of those points was a matter of public concern, but collectively, they were indicative of a personal grievance. And then this court applied the balancing test in the Connick test and looked for potential for disruption. District courts—
Counsel, before you turn to the Pickering or the balancing test, I just want to make sure that I understand. What is your perspective on exactly what the speech was here? Was it the original Facebook post? Was it liking someone else's, or retweeting or liking someone else's comment there too? How do you that universe of the speech?
Her speech would be her original post, which she did actually have the opportunity to remove when her supervisor asked her to.
Why would it not include her liking someone else's post, which suggests effectively, endorsing that particular perspective?
Your Honor, the like of her post is a recognition that she was reposted, but a Fourth Circuit court case, Bland v. Roberts, did find that a like is speech, but in that specific case, that was regarding a public employee's freedom to like or support an opposing political candidate. And the two following cases also were under those very narrow restrictions. First, this court has never found that a like is speech. Second, those are very narrowly applied. And third, that would be a very broad application of very small issues. So for example, if a public figure accidentally liked a comment on a Twitter feed, or we want to give them the freedom to remove that like and not be held obligated that that is in fact speech to which they are on the hook for.
So, counsel, I think the record reflects that 20,000 people viewed her original post. Is that correct?
Yes,
so
Your Honor.
Doesn't that almost in an axiomatic way, establish that her speech was a matter of public concern?
Oh, forgive me, Your Honor. 20,000 people viewed the repost of it, the Mother's Milk post. And you bring up an excellent issue there, that this is a city, as we see on the record at page 5, of 90,000 people. If 20,000 people screenshot this post, 1,600 people like this post, and countless others saw this post, even if half of the people who screenshotted or liked it refused the vaccination, that's 11% of this population.
But that seems to me, Counsel, it goes to your balancing test, which it seems to me that's how you win or lose this case, because it's clear to me that there is at least a very colorable defense that's been made with respect to this being of public interest. So then we're into the balancing test. So my question to you would be this. Let's assume a different set of facts. Let's assume that the compounding for the vaccine was flawed in some way, and it was making people sick. And there was frequency and experiences in a significant number that mirrored the plaintiff's experiences. Would your position on her speech be any different?
If she has firsthand knowledge of this based on her work at the health department?
No, the facts are identical, other than it turns out that the compounding was flawed, that the vaccine was making people sick.
And she doesn't know this. She's just still complaining about her vaccine?
Oh, she was complaining about her vaccine. It made her sick. She posted. Social media magnified that post significantly. And then it turns out that a number of people were getting sick from the vaccine that the health department was administering.
Well, Your Honor, that is an entirely different set of facts. We would still argue that her speech is not an informed opinion if she's not one of these people who have in fact been sick. But again, her speech would be subjected to the balancing test here. And Your Honor, this court held in Connick v. Myers, we have given substantial weight to government employees' reasonable prediction of disruption. And held in Waters v. Churchill, we have consistently given greater deference to government predictions of harm. Opposing counsel brought up that there was a minor inconvenience. And Your Honor, this court, with its foresight, never added a qualifying adjective to these predictions of harm or these potentials of harm. They just had to say the government had to present that they do in fact exist and they are reasonable. And as you all brought up, with these 20,000 screenshots and the 1,600 likes and the 10 people called hesitant, those are real possibilities for disruption. There's already an actual disruption.
Counsel, my issue with that is one, in at least one of the cases where somebody cited this Facebook post, the doctor was able to talk to them and they still got the shot. And my second issue with this part of your argument is that it's my understanding that the petitioner continued to hand out the information regarding vaccines the same as she had been doing before without any substantial change. So does that not in fact weigh against you in this instance?
Your Honor, again, there's that potential for disruption. The pediatrician of whom you spoke emailed the health department questioning her continued affiliation with the health department. And that is an obvious disruption in a previously agreeable work environment. And there's also...
Counsel, if you can finish that thought and then be done, please.
Thank you. We also see evidence of interpersonal conflict as well between these co-workers, and Your Honor, because of these things, because this is a matter of public concern, is an informed opinion, and because the government agency in this case is weighed heavily in favor of disruption-free workplace, we ask that the court would affirm. Thank you, Your Honors.
Thank you, ma'am. Is counsel for respondent number 4 ready to proceed?
Yes, I am, Your Honor.
All right, sir. Whenever you're ready, you may begin.
Chief Justice, and may it please the court, my name is Robert Rimber, and I also represent the respondent, Rockland City Police Department. For 3 reasons, this court should affirm the 14th Circuit decision that there was no search, and that even if there were a search, it was reasonable. First, this case of tire chalking fails the CAT's reasonable expectations of privacy test. Second, this case fails both elements of the Jones test. Third, even if this court finds there was a search, it was reasonable because the community caretaking exception does apply. To my first point, Your Honors, marking a tire with chalk fails the CAT's test because the petitioner had no reasonable expectation of privacy in the non-movement of her vehicle in a public parking space. This court said in Cardwell versus Lewis in 1974 that rather than property rights, the primary object of the Fourth Amendment was determined to be the protection of privacy. That's why the CAT's reasonable expectation of privacy test, it states that what a person knowingly exposes to the public, even in his own home or office, is not the subject of Fourth
Counsel,
Amendment protection.
has the other side even argued CATs, or have they waived that? Why are we talking about CATs?
They have not discussed CATs, but Your Honor, we feel that the CATs is the appropriate test to apply because the threshold question is whether or not there's a physical intrusion. And as you alluded to, for the petitioner's side, this is a very minimal mark on her vehicle. And so because it's not a physical intrusion, the CATS test will apply, but even if this court finds a physical intrusion, it still fails the elements of the Jones test.
Do you win because it's a minimal physical intrusion, or because physical intrusion isn't the question we should be answering?
Physical intrusion is still the question, Your Honor, but a non-actionable technical trespass to chattels is not the type of physical intrusion that the Fourth Amendment was intended to protect. In fact, in the United States.
So where do we draw the line? I mean, but could you have spray painted her tire?
Spray painting, the officer could not have spray painted her tire because we're not asking the court to overrule Jones. We are asking the court to clarify the definition of a physical intrusion. And our contention is that an actionable trespass, something that causes damage or undermines the value or quality of the chattel, that is the type of physical intrusion that underpins the Fourth Amendment. That's why Justice Scalia in the United States versus Jones opinion, he pointed to a case from England from 1765, Intig versus Carrington, and said that it would have been on the minds of all the framers at the time the Fourth Amendment was adopted. And in that case, officials broke into a home and over the course of 4 hours removed papers from that house.
But Jones and Hardeen's did not involve any damage to any property. What language can you point us to in Jones or Hardeen's to show us that your test is the test that this court has even countenanced, that there's any sort of de minimis exception?
Yes, Your Honor. In both those cases, in Hardeen's, it was a trespass to land, trespass to property. And the common law has afforded property, real estate, more protection than trespass to chattel. That's why Taylor versus City of Saginaw, the judges in the Sixth Circuit, they went to the restatement, section 217, for the definition of trespass, and which says it's any intentional touching. But they said that the Jones opinion does not provide clear boundaries for the common law definition of trespass. They could have just as easily turned to the next section in 218 to look at what makes an actor liable for trespass, and that requires some kind of damage or depreciation of value of the chattel itself. And so our argument is that preventing officers from doing a non-actionable trespass to chattels different than real estate, that is not the type of intrusion, that it's not an intrusion, and it's not the type of activity that the framers intended the Fourth Amendment to prevent.
I'm going to pick up on Judge Mansangani's question. So Jones, how did the attachment of the magnetic GPS tracker to the car satisfy this test that you're telling us?
In Jones,
diminishing the value of the chattel.
Yes, Your Honor. As you mentioned to the petitioner, affixing a GPS device to the car over the course of 4 weeks is very different than a mark of chalk that's placed on the exterior of a tire that's going to fade with the elements in a short amount of time. And so that level of intrusion is, in fact, an intrusion in Jones, but the concurrences also note that they do note that it caused no damage to the car. And so there wasn't a complete agreement that that even was a physical intrusion. In fact, both concurrences looked to the privacy interests of the individual and decided on a privacy interest consideration using the Katz formulation. And so there wasn't a complete agreement that even in Jones was a physical intrusion under the test.
Counsel, can I ask, I'm going to steer you a little bit off judges' questions here, but for a warrantless examination of an exterior of any premise, even a tire with a chalk mark, don't you have to establish probable cause? And can you explain what you have in this case?
Yes, Your Honor. That would assume that there was a search, which we argued that there was not a search. But if you get to the reasonableness and the requirement for a warrant, for the community caretaking exception to apply, there does not need to be probable cause, as the petitioner said, because it's totally divorced from the investigation of a crime. And so for the caretaking exception to apply, which it does in this case, there does not need to be probable cause because the officer isn't even looking for a crime in that case. The exact language from Katie versus Dombrowski is that the search was reasonable because its purpose was for the concern for the safety of the general public who might be endangered if an intruder removed a revolver from the trunk of the vehicle. It was about the safety. And in terms of being divorced from the detection of a crime, it specifies the exception does not apply where the officer believes the operator has violated a criminal statute. And based on that precedent in South Dakota versus Opperman, the court also held that the search, it was not a search because the officer made no discretionary determination to search based on a judgment that certain conditions were present.
But why? What belief did the officer have in chalking the tire that she was violating the law, since he chalked the tire at the time that she was complying with the law?
Yes, Your Honor. Officer Hadley did not have a reason to believe that she had already violated the law. What she had was a reason to believe that a car that does violate the law will pose a safety hazard to the community of Rockland.
So can you share very specifically what that safety hazard would be?
Yes, Your Honor. Rockland, per the record on page 5, is a community of 90,000 people. In the first 7 months of 2019, there was a 5% increase in violent crime and automobile-related burglaries in the part of downtown in which the petitioner parked her vehicle. In fact, she was parked at a jail in an area of the lot that had no parking lights. And so she was parked in the dark for multiple days. And that's the exact type of situation that would make a vehicle liable to be intruded upon by a criminal. And so in the record shows as well on page 14 that the purpose of this ordinance is to ensure the traffic flow and the safety of the general public. But Your Honor, if we could circle back to Jones for a minute, our argument is that the physical intrusion, that there was no physical intrusion because it was an unactionable trespass. So the line we're asking the court to draw is that there be some sort of damage to the vehicle or to the chattel that would be a trespass under Restatement Section 218, that would be a triggering of the Jones test. But even so, as petitioner noted, it would still need to be to obtain information. And then the court has not used Jones to restrict the government from obtaining information already exposed to the public. In Jones, it generated over 2,000 pages of data over the course of 4 weeks. That generates a lot more information about an individual than just the non-movement of a vehicle in a public parking space. In fact, Justice Sotomayor said in the concurrence that GPS monitoring generates a precise and comprehensive record of a person's public movements that reflects a wealth of detail about our familial, political, professional, religious, and sexual associations. And that is true when you're looking at tracking over the course of 4 weeks. And that's movement versus non-movement in our case. Similarly, in Florida versus Hardinez, the court, 7 of the 9 justices of this court looked to the type of information that was obtained by the search. And those justices said that the information was unattainable absent the intrusion on the property. And as your Honor pointed out, Officer Hadley could have ascertained the location of the vehicle through mere observation, through taking a photo. That would actually, though, create more of a record. Yes, Your Honor.
Counsel, does the amount of knowledge that law enforcement needs to be able to glean from the search need to have a nexus to the type of crime that law enforcement is trying to prove? So it seems to me in Jones that they needed all that detail to prove up the crime that was at issue. Here, the only thing law enforcement needs to know is, did this car move? And it seems to me that if that's all they need to know, well, have I searched the car for purposes of determining whether this crime was committed? Both of those boxes are checked here. And so does the type of crime the law enforcement is trying to prove have a bearing on the knowledge prong?
Yes, Your Honor. Justice Scalia actually specifically answered that question in the opinion, and he said he knew of no cases in which the type of crime that officers were investigating, that had any bearing on the type or amount of information. Rather, in this case, it's not the amount of information. That's one part of it, but it's also the type of information that was unobtainable absent a physical intrusion. And so in this case,
that's not true, is it? It is true, rather, that there are alternatives to the trespass. Officers could take a photograph of the car, which would include a timestamp. I mean, isn't that a much more verifiable, much more responsible conduct in the community custodian set of responsibilities than a trespass, even if it's minor?
Yes, Your Honor, and that does speak to the reasonableness, but in Katie versus Dombrowski, this court specifically said that the existence of less intrusive means does not determine whether the caretaking exception applies. So we're not arguing that there are less, there are not other means by which, but other means that the city could use are arguably even more invasive than and would infringe privacy interests, even more than just marking a chocolate tire, such as you mentioned, taking photographs or keeping some kind of log that could be a storable record.
So is the taking of a photograph, if there would have been a photograph of Miss Redding's vehicle, is that a search?
That's not a search, because this court has held in United States versus Knox that observing, just the mere observation of a vehicle does not is not a search, because it's in plain view. And so the petitioner's argument is that that there was a physical intrusion, but Your Honors, this is not a physical intrusion. But another issue is that lower courts have misinterpreted what the language of the physical intrusion means. That's why in Taylor versus City of Saginaw in the Sixth Circuit, they held that marking a tire with chalk was a physical intrusion. And in this case, in the 14th Circuit, the court said that marking a tire with chalk is not a physical intrusion.
What if they had attached a magnetic device to the car that was only a proximity sensor? The only thing it told you was whether or not the car had moved, not where it had gone or anything else, but just give you the exact same information that a picture or a chalk mark would. But this time it was a magnetic device, not unlike the size of the device in Jones.
In that case, we would ask this court to apply the actionable trespass line, and if there is some sort of damage to the car, then that would maybe implicate the Jones test.
Was there any damage in the record in Jones, anywhere in the opinion?
There was no damage in the record, but the concurrence, 5 of the justices did note that there was no damage. It wasn't the majority opinion, but this court was not unanimous on the fact that there being no damage was a proper consideration for the Jones test. And so
you haven't answered, I can't remember, I think maybe it was Judge Wyrick that asked you, what is this line? And you just said that a photograph would be okay. And now you're trying to tell us that touching something and altering it, believe me, I wouldn't be too happy about someone marking up on all my tires. So can you say why you believe that just because it's a less of an intrusion versus no intrusion on the car, how that gets you over the hump here?
Yes, Your Honor. our argument is that a non-actionable trespass to chattels is not the type of physical intrusion that was envisioned by the Fourth Amendment. Justice Scalia said in United States versus Jones that at minimum, we must protect the level of privacy that was afforded at the time of the Fourth Amendment. And he based that on the case of Intick versus Carrington, which it was trespass to land and real property. And so trespass to just unactionable trespass to chattels is still consistent with the level of privacy afforded by the Fourth Amendment. But Your Honors, because the Katz test is the proper test to apply, because there wasn't physical intrusion, there was no search. But even if Jones applies, the type of information obtained was obtainable absent the trespass, and therefore it was not a search. But even if it was, the community caretaking exception does apply. Thank you.
Thank you, counsel. Yes, ma'am. Are you ready to proceed with your rebuttal?
Yes, Your Honor.
All right, whenever you're ready, you may proceed.
Thank you. Your Honors, Ms. Redding's First Amendment rights were violated when she was fired for her Facebook post. Respondent contends that Ms. Redding's case is similar to Connick versus Myers and Waters versus Churchill's, which rely on internal functions. The government in those cases were concerned with speech within the government entity that disrupted trust between employees and significantly impaired the entity's ability to function. Ms. Redding's post encouraged individuals outside of her employment to seek more information about their health, something that we should encourage in a time like today. Furthermore, the fact that this court is in contention shows that there is a material question of fact, making summary judgment inappropriate in this case. As to the Fourth Amendment issue, the respondent relies on the amount of information gathered in Jones to distinguish this case, but the court in Jones specifically declined to set an explicit amount of information necessary to meet that threshold. We do not deny that the government has legitimate interest in reducing criminality. We simply ask this court to make the government carry out those interests in a way that does not violate individuals' Fourth Amendment rights. For these reasons, we ask this court to reverse the 14th Circuit decision and remand back to the district court for further proceedings. Thank you.
Thank you, counsel. Thank you, everyone, for their wonderful arguments. The court is now going to conference, and we'll be back with you shortly. Thank you for your patience.
I do want to just take this time to thank all of our judges. You all are good friends of OU Law, and we certainly appreciate you taking time and joining us in this experiment, which I am happy to say we are moments away from finishing 3.5 weeks of this. And I also want to say congratulations to our competitors. They are wonderful advocates who worked hard to get here in the final round. I will get to work with them in future years on competition teams, and I'm pretty excited about that. All right, I'm turning it over to you.
All right. All right. First of all, I want to express how impressed I am with you as first-year law students to attack such a, what I call an absolute craft, which is appellate argument. You all did a very professional and prepared job, especially in a time where I know you're not at school and you're doing things from home and doing things in a different way. And we all very much appreciated all of you have done. I thought that all of you did a good job in not even on Zoom interrupting a judge when they're speaking in an appellate argument and addressing the questions that were asked, even if they were difficult questions. Judges want you to listen to the question and answer it as honestly. They're trying to learn and understand your position. And I thought each of you did well in expressing that opinion. Those are my first thoughts. Judge Mancingani, do you want to go next?
Sure. I thought all the advocates did a really great job. It's clear that all y'all have a great grasp of the case law and the record, and that's always what's most important. Y'all were great at answering questions very directly. Speaking as somebody who's in court every once in a while, it would be great if all advocates were as skilled and as candid with the court as y'all were.
Judge Mueller, do you have any comments?
I will second that you all did a fantastic job. And I'm not just saying that as somebody who's evaluating for a potential team next year, but honestly, for 1Ls and with all the changes I know you all have probably gone through over the last few months, you all did a fantastic job with your arguments. I thought you did a great job not interrupting us and trying to listen to that question and answer it. My one critique that I would give is never be afraid to sort of take a little bit of a second just to kind of gather your thoughts, especially with sort of these different technologies we're trying to use. Sometimes you can kind of catch the hesitation a little bit better, but I thought you all did a truly fantastic job. And I do want to thank Professor Smotherman for all of her hard work in getting this set up for her. This is the second competition I've done by Zoom, and both have been done fantastically. So I will say thank you to her as well.
Thank you, ma'am. Judge Guzman, do you have any comments?
I echo that which everyone else has said. I frankly, I mean, it might sound like it's an overblown statement, but I mean it with, to the depths of my core. I think that participating in this way and arguing in this way and stepping up and doing that which you have done, especially as first-year law students, has been truly heroic. And so your efforts and the assistance and the support of Professor Smotherman and Ms. Huffy's and Ms. Ricard and every other law student really has just shown your abilities. I date myself when I say this. My first year of law school, I was petrified when we had our moot court competition, and the remarks for me basically were, "You look like Lilith from Cheers," because I was just holding on, and Lilith apparently was very high strung and very anxious all the time. I didn't see that from you all. I just felt like you were profoundly successful and heroic in all of your efforts. And I could not compliment you and Professor Smotherman and the entire team anymore.
Thank you, ma'am. Justice Wyrick, do you have any comments?
Yeah, well, first, I just want to congratulate everyone for making it this far. It's obviously a very competitive competition, and also applaud everyone for rolling with the punches and being able to argue so capably in this odd format. And it's a good skill that you're going to need in life. Here at the federal court, we're currently conducting proceedings via video. It's awkward and it can feel strange, but in times like these, you argue the case as it's presented to you. Mithen's going to find that out here in a few weeks. He's going to argue for the United States Supreme Court via telephone, and it's going to be different and weird, but you know what? He's got to do it that way, and he's going to be great because you argue the case as it's given to you. So I applaud y'all for really handling the format of the argument remarkably well. All of you are very good advocates. I will say I particularly thought both Jessica and Robert had the type of demeanor and presence and calmness and ability to answer questions that I think will serve them very well if they choose to be appellate advocates in their future. So again, everyone was great. Good job, and way to roll with the punches.
Thank you, sir. And Attorney General Hunter, you have any comments?
Thank you, Your Honor. Well, I saw A+ advocacy out of all four of you today. It's hard to stay at an A+ every day, particularly every day that you're in court. And I wouldn't mislead anybody who argued today to tell you that you're perfect. But as I said, there were A+ moments for everybody today who argued. As a 1982 graduate of the OU College of Law, I continue to be impressed with the quality of students, dean, that the law school is able to convince to enroll. The degree that I have has certainly taken on more value since 1982, based on the quality of law students that I'm seeing, and y'all are no exception. Great work. You knew the law. The poise that you exhibited today is essential to being a good advocate, to being an effective advocate. So in summary, I can't say enough about the talent that I saw today, the professionalism, and I look forward to seeing you all as applicants for a job in the Attorney General's office someday.
Chief Justice Keene, if I could interrupt for a moment. I appreciate all of your comments and do again want to say thank you so much to our judges. If I could have our competitors turn their cameras back on for the announcement. This is a money round. All these competitors will receive monetary awards from Witten Burrage. They will be recognized tomorrow evening at the competition awards banquet. And then I will see you all next year. Looking forward to reading your competition team applications. Okay, Chief Justice Keene, I turn it back over to you.
Yes, ma'am. At this time, after deliberation and conference of all 6 justices in this case, the justices have voted that the petitioners group has won the argument today. Congratulations.
Thank you very much for your time. Yes, congrats. Well
Thanks,
done.
all of y'all.
You guys
Congratulations.
were amazing. Thank you guys all so much.
Congratulations, everyone.
Yes, good job,
Congratulations.
everyone.
And thank you. And to all of you all in the viewing room, we hope you enjoyed watching this. It was an event, but now it is done and it is now a triumph. So thank you for joining us and have a good afternoon.